Hi, I'm Elizabeth Gearhart. I'm here with Richard Gearhart from Gearhart Law, a full service patent, trademark, and copyright law firm that also does litigation and works domestically and internationally. Welcome, Richard.
Well, thank you for having me, Elizabeth.
So, why do people choose Gearhart Law over other patent law firms?
I think the fundamental reason is results. I think we get results for our clients. We get their patents and their trademarks and their copyrights granted from the Patent and Trademark Office and the Library of Congress. And we get results when we litigate cases too. So it's the combination of results and value that brings clients to us and keeps them as clients.
Who are your main clients? What are they? Small businesses, entrepreneurs, large corporations? Who do you work with?
Well, we work with a range of clients, everywhere from individual entrepreneurs, solopreneurs to large Fortune 500 companies. But our sweet spot is really working with entrepreneurs, and we really enjoy helping them protect their ideas and their inventions, and helping them grow as companies. And we love seeing them start off with an idea and turn that idea into a project, and then eventually to a successful business.
What kind of technologies do you work with? Is it just consumer products like gadgets that people would use at home, or is it apps and tech? Is it anything with medical?
Well, we cover all of the above, Elizabeth. We do both life sciences projects, which is what my background is, medical devices, pharmaceuticals. We also do a lot of work in the consumer product space, so new types of consumer products that you might find at Target or Walmart. And finally, we do computer software, apps, or other mainframe types of software programs that are in the tech industry. So we cover all bases at Gearhart Law as far as technologies and projects are concerned.
So by me, I assume that it's not just you. You have other attorneys that work on these projects.
We have a great team of 14 colleagues that help us provide excellent service to each and every client that comes to Gearhart Law. And so we're very proud of them. Nobody can do it on their own, and that's certainly the case in the intellectual property field.
Wonderful. So if I had an invention and I went to you versus Invent Help, what are some of the, I guess, perks, or what are some of the special things that a law firm would do versus like an Invent Help company?
Well, first of all, you have to be licensed to be an attorney, which means that you have to complete 3 years of law school, which isn't easy. And then you have to pass a state bar examination, which is also not easy. And on top of that, if you want to practice patent law, you have to receive permission from the USPTO by taking another examination. So the people who work at law firms are highly qualified. In addition, it takes a lot of training to become an intellectual property lawyer. It's not all just memorizing regulations and book sparks. It's a job that requires a lot of experience. So the attorneys at Gearhart Law, whether it's a trademark, patent, or copyright, have seen thousands of fact patterns, thousands of different inventions, thousands of different trademarks, and thousands of different copyrights. And so because of that experience, we're able to get good results for our client when it comes time to obtaining patent, copyright, or trademark protection.
So as a law firm, does that mean I have attorney-client privilege?
You got it. You can pick up the phone, you can tell us anything that you want, and we're bound by confidentiality rules of the Bar Association. You have the attorney-client privilege, and I'm proud to say that we've never had any issues with that, and we've always kept our clients' information in the closest confidence, and that's really fundamental to being an intellectual property lawyer. Lots of times people tell us their invention before they tell their spouse or their members of their own family, for example. So that bond of trust is really, really important.
Does it cover just the lawyers, or does it cover everybody in your firm, like the paralegals, the marketing department, accounting?
And well, everybody within the attorney span of control. So any support staff are also considered to be under the attorney-client privilege.
Okay. So I've heard people call themselves intellectual property attorneys, but they don't do patents. So how could they do that? What's the difference?
Well, technically that they're not making an error. Usually they're general practitioners who also do trademarks. And for some clients, that's fine. If you have a relationship with a business attorney, for example, and they do trademarks, you should certainly consider their services. But we're experts in trademarks because that's all we do. And trademarks aren't as easy as some people would lead you to believe. There's a huge body of case law around what kind of marks can be granted. There are opposition proceedings at the US Patent and Trademark Office where people can challenge your trademark, and there's federal litigation too. So when we draft a trademark application, it's with all those rules, regulations, and experience in mind. And so while some lawyers do have expertise in trademarks that are also not patent lawyers, and so they do practice intellectual property. Our recommendation is that if it's an important trademark, make sure that you work with somebody who has a lot of experience in the area and is not just a filer of trademarks.
So if I come to you or somebody in your firm with an invention and I want to start a business, so I might need a patent, I might need a trademark, I might want a copyright. I don't really know where to start. Do I necessarily have to get all those things to start off with? How do you approach a project?
Well, so each project, each client is a special project. Each client has different needs. They have different goals. They have different objectives. Some clients want to build a business and then sell it off. Other clients want a lifestyle business where they can make money from their project until they decide to retire. How you plan to run your business is very important in terms of the types of intellectual property that you select and how you go about doing it. So the first thing we do is try to understand what the client's goals, and we're very good listeners at Gerhardt Law. We listen very closely to your project, and every project that we encounter at Gerhardt Law is treated with the utmost respect because we understand that it's your project and it's something important and special to you. And sometimes you're going against the grain and not everybody else may think the same way, or you're concerned that they may not. So the first thing that we do is speak with our clients and make sure we understand their goals. And then we work out an IP plan based on what makes sense to do what first. So sometimes it makes sense to do a trademark first. Sometimes it makes sense to do a patent first. Sometimes it makes sense not to do any intellectual property. And so we take time to understand what each client wants and what their business goals are. And then we create a custom plan for them around their protecting their business.
So if I come to you with my idea and we sit down and talk about it, do I get charged for that?
No, our first consultation is complimentary. We're happy to talk with anybody who has an intellectual property need. And we work hard to make sure that we come up with the best plan to fit your budget and the needs of your business.
So what happens if I get a letter from a law firm that says you are infringing my client's patent, trademark, copyright? What do I do?
Well, the first thing you should do is contact a competent intellectual property professional and they can evaluate the situation. You do need to take those letters seriously. Sometimes our clients will put off sort of addressing the issues until the deadlines start to pass. And it's usually better to get somebody involved in the situation before it gets out of hand. And there are almost always strategies that we can help you develop. If there is an infringement issue, we can, for example, help find ways to create defenses and fight back. And if we try to avoid litigation, our first preference is to settle the prospective dispute without going to court. Of course, sometimes that's not possible, and in that case, we will, defend you in court or pursue your claim against somebody else if that's necessary.
So is Gerhardt Law involved in any litigations right now?
Yes, we have quite a bit of litigation. We live in America, a litigious society. That goes for patents, trademarks, and copyrights, along with just about everything else. So yes, there is quite a bit of litigation activity at Gerhardt Law. And I would also say, though, our advisory practice, preparing applications and prosecuting them with the patent office, is also very active.
So one last question for me. If I have a trademark here in the United States on Fireside, for instance, and I want to pursue having Fireside do business in, say, the EU or China or somewhere, do I need to get a trademark in those countries too?
Yes, absolutely. So patents and trademarks are territorial, which means you only get protection for the countries where you have the registration. So if you want to protect your invention in Canada, you need a patent in Canada. If you want to protect your trademark in England, we have to file a trademark in England. And there's a complex system of getting international intellectual property. Fortunately, Gerhardt Law has a lot of experience in this area, and we can help guide you through the process if those are your goals.
Wonderful. Is there anything else that we should say about Gerhardt Law?
We pride ourselves on being supportive and friendly and approachable. We like to think that we're especially good at gaining our clients' trust. Our clients like us, and we like them too. So we would be happy to talk with anybody who has any questions about intellectual property.
Thank you.